Just operating from home this afternoon.
Good. Great. Well, I think I heard the recording in progress, so we're going to go ahead and get started. Good afternoon, everyone. Thank you for joining us today. I hope you can still hear me okay. Can I get a thumbs up? Someone? Yeah? Okay, great. Thank you. All right, so we're really excited to have this presentation by Judy Bordeaux on immigration matters for clinicians, researchers, and other professionals. Before we begin, I would like to read a statement from our Senior International Officer, Kimberly Connolly, and the Office of International Programs. So happy International Education Week 2022, and welcome to this program sponsored by the Office of International Programs at KUMC. International Education Week is a week for celebration, a celebration of diverse cultures, languages, people, and the relationships and connections we have forged here and across oceans and continents. This is a time to celebrate our friendships and to celebrate in our collective and individual accomplishments. According to the Department of State, International Education Week, which is from November 14th through the 18th this year, is an opportunity to celebrate the benefits of international education and exchange worldwide. This joint initiative of the U.S. Department of State and the U.S. Department of Education is part of our efforts to promote programs that prepare Americans for a global environment and attract future leaders from abroad to study, learn, and exchange experiences. Here at KUMC, we know very well how much our international friends and colleagues contribute to our community and how grateful we are that they choose to work, study, or do research here at KUMC. Diversity is essential to creativity of thought and expanding our mental horizons and understandings. Simply put, we all need to interact with others who think differently and perceive the world differently, as it makes each of us better, smarter, and a little more empathetic and understanding. As Senator Fulbright stated, we must try to expand the boundaries of human wisdom, empathy, and perception, and there is no way of doing that except through education. The essence of intercultural education is the acquisition of empathy, the ability to see the world as others see it, and to allow for the possibility that others may see something we have failed to see, or may see it more accurately. We know the value of individuals from around the world who come to the US to study and how their presence in America contribute even more profoundly than the billions they contribute yearly to higher education. NAFSA, the National Association of International Educators, analysis of the 2021-2022 academic year shows that international students and their families contributed $33.8 billion to the US economy. In the state of Kansas, the 8,272 international students enrolled across the state contributed $214 million and supported 1,661 jobs. We are situated in the heart of America, and many may wonder how our international folks find their way to us. We celebrate the journey of those who come to KUMC, their presence and their immense contributions to enhance our lives every single day. International students, researchers, and employees are part of the heart of our institutions and are woven into the beautiful tapestry of American higher education and American society. Many come to KUMC through the relationships our faculty and researchers have developed over the years through collaborative, mutually beneficial programs and endeavors. We celebrate our faculty, researchers, and administrators who approach international exchange and global health with attitudes and efforts that reflect humility, inquisitiveness, and understanding. Many of our learners, 200 yearly, travel to our partner hosting institutions to learn about clinical care, the strengths of other healthcare systems, and the beauty of other cultures and languages. We celebrate our learners who seek to understand other healthcare systems, social and economic health disparities, and innovative patient care from around the world. Many of our partner institutions send their learners to KUMC participate in virtual exchange, or host our faculty and learners to exchange ideas, learn and research together, and even to share meals together. We celebrate our partners who make these deep learning experiences possible. Each one of us are part of the international exchange as we are part of the KMC community. This week is all about all of us exchanging and listening and interacting together. Happy International Education Week 2022. All right. Well, just a few quick rules about the presentation. There will be time for Q&A at the end. So we'd like to ask that if you have any questions, to please feel free to ask at that point. Additionally, you can post your questions in the chat. We will be monitoring it and we'll make sure your question gets answered. Without further ado, I would like to introduce you to Judy Verdeaux, attorney and KMC's university-approved immigration attorney. I'm always excited to hear Judy speak on immigration matters. It can be an incredibly complex topic, and she is a master in breaking it down to something more easy to understand and navigate. Judy has practiced immigration law for almost 25 years, and she is licensed to practice in both Kansas and Missouri. She has worked in private practice and as an in-house attorney for a multinational company, giving her a broad understanding of the issues that face employers and foreign national workers. Judy is an active member of the American Immigration Lawyers Association, AILA, and she has served on both the Business Immigration and the Department of Labor liaison committees for the American Immigration Lawyers Association. Judy is a frequent presenter at local, regional, and national forums regarding immigration matters. She speaks fluent Spanish and has traveled extensively in Europe and Latin America, and we're always so happy to have Judy here with us, albeit virtually today. But please help me welcome Judy Verdeaux.
Thank you, Arena and Kimberly and Stacy and everyone there in the international office. And I just would like to reiterate Kimberly's and Arena's message there that you all read. My shortened version is that I think you're all awesome. And having been an international exchange scholar myself at one point to Spain, I do know that it's a really very worthwhile endeavor on so many different levels. This presentation is one that I give to a lot of different universities every year. I have tailored it a little bit to KU Med because there's a little bit more information in here that's relevant for clinicians and researchers and allied health professionals that might not be relevant to such an extent at another Kansas or Missouri university. This is designed to break down, as Irina said, immigration into understandable steps and understandable jargon. One of the things that we do a lot of times in the immigration world is you'll hear us talk in all kinds of different letters and numbers, and it can be very, very confusing. And what I would like to do is share with you all the legal requirements and how the government looks at these various employment-sponsored work authorization and employer-sponsored permanent residency. There are other ways to get work authorization in the United States. I'm going to hit on a little bit of them. Most of them are either through applying for TPS, temporary protective status, marriage to a U.S. citizen or another qualifying relative in the United States. Some people apply for asylum or refugee status. Some people participate in something called a diversity visa lottery and can get work authorization that way. But what I'm going to talk you all through today is a fairly normal progression where someone starts in F1 or J1 status and then obtains an H1B or other non-immigrant visa for work that is sponsored by an employer and then seeks permanent residency in the United States through their professional training and their employment opportunities here in the US. So that's the scope of this conversation. I just want to make sure that everyone understands that it's not going to cover everything. I'm really focusing on What most people are going to see who don't have options through family or asylum, or you're not from a country where there's temporary protective status and you would like to stay in the United States on a long-term basis. So with that, first of all, what I would like for people to understand is that there are two different ways of talking about immigration in the United States. Mostly what we're talking about visas. And there are two different types of visas. One is a non-immigrant visa that typically starts with a letter. So it might be an F1, a J1, an H1B, an H2B, an O1, an R, an L. And in fact, a non-immigrant visa in the United States, the alphabet right now starts with A and goes all the way down to V, okay? And in some of them, there are subsets. There's an H1B, an H2B, an H2A, and those letters come from the statute. When you're talking about regulations in the United States, you'll hear 8 CFR 101A, right, or B or C, and that's where these non-immigrant letters come from. Not all of them authorize work. In fact, many of them don't. A B visitor visa, for example, does not allow someone to work in the United States. It only allows someone to visit for tourism or to see family or friends or to come for a business purpose. But something that everyone needs to understand about a non-immigrant visa that's a letter visa is that they are typically restricted in terms of time and restricted in terms of activity and restricted in terms of employment. So time, activity, and employment. So if employment is authorized, it's usually even further restricted to a particular type of employment and or to a particular employer. So many of you who are studying at KU Med may end up with optional practical training when you finish. That is F1 work authorization, but you are required to work in your field in an area of practical training that is related to your degree, correct? And it is time limited for either 12 months or 36 months, depending upon whether or not you're considered to be in a STEM field, science, technology, engineering, or math, okay? So I'm going to talk about the most common types of non-immigrant work visas in the US. I'm not going to talk about the R religious workers. I'm not going to talk about the L1B specialized knowledge for intercompany managers or executives or the G government visas because I don't think they're going to apply to most of you. But again, there is a very, very long alphabet of different types of non-immigrant visas, from everything from visiting to a crew member on a ship to a religious worker to someone who is here based on being a translator or a victim of human trafficking, okay? So there are lots and lots of different types of non-immigrant work visas in the United States. An immigrant visa is the same thing as permanent residency or a green card. And we tend to use those terms interchangeably. The immigrant visa is actually something that you would get if you applied at a U.S. consulate abroad. They would put a visa stamp in your passport, okay? Permanent residency is sort of a status in the United States of being a permanent resident, and a green card is the actual document that you get, and it's back to being green again. It was pink for a while. It's not always a green card. The advantage to getting the green card is that if you do have a green card, you have unrestricted work authorization to work for any employer in the United States or to work for no employer at all. And they are also not time restricted. You don't have a limit on your permanent residency. Unless you abandoned it by staying outside of the United States or lose it by becoming a criminal and selling drugs, for example, which we certainly don't want you to do, a permanent resident can be a permanent resident for 20, 30, 40 years, unless you decide to become a U.S. citizen. So green cards or permanent residency, again, are most commonly obtained through employment or family relationships, okay? So we're going to talk about both of these. We're going to talk about the non-immigrants and the immigrant visas today. Okay. As you know, the purpose of the F1 visa is to study in the United States. And again, I'm not going to go into a long discussion about OPT work authorization. You're going to want to talk to Arena and Kimberly about that in the international office. The J1 visa, I am going to talk about a little bit more. It is for international scholars, students, researchers, exchange visitors, physicians oftentimes. And the students need to check with the J1 program about work authorization. Again, the J1 has a training ability, much like the F1 has the optional practical training, and individuals can work in J1 status in most situations, and that is coordinated with the program sponsor. Something that I do want people to know who have J1 status in the United States is that many J1s carry with them what's called the 2-year home residency requirement. And you will be subject to that 2-year home residency requirement if you received government funding from the United States and even from your home country. If your field is on the skills list from your home country, the Department of State maintains a skills list in the Federal Register, and individuals, particularly from less developed countries, may be required to go home when they finish their J1 program to bring the knowledge that they gained from the United States back to their home country to benefit the home country. The idea of the exchange program is to benefit the home country and for individuals to learn about the United States and to take that knowledge home. If you have received medical training on a J1, ECFMG residents and fellows, you are also subject to that 2-year home residency requirement. What that means is when your DS 2019 ends, you cannot change status to H-1B. You cannot get an H-1B at a U.S. consulate abroad. You cannot apply a change status to any other status from within the United States, nor can you apply for permanent residency with that 2-year home residency requirement. However, there are ways to get that J1 2-year home residency requirement waived, okay? Again, if you have that 2-year home residency requirement, you cannot change to H-1B or file to an I-485 adjustment of status until you complete the 2-year requirement or obtain a waiver. To obtain a waiver, you need to complete a file with the Department of State and obtain supporting documents depending on the reason that you're subject to the 2-year home residency requirement. If your field of study is on your country's skills list, then you must obtain something called a no objection letter from your home country. And that basically means that your home country does not object to you remaining in the United States, okay? If you received government funding, you oftentimes need to receive a no objection letter and a no objection letter from the government agency or the organization that provided the funding. If you are a physician, that you've got a few different options. The most common is called a Conrad State 30 waiver. Physicians who received their training in J1 status may attempt to get a job in a state that is willing to, where the employer can file for a Conrad State 30 waiver. Every state can grant up to 30 waivers for physicians that will be working in medically underserved areas, or some states even take the option of allotting 10 of those slots even for physicians who are not working in medically underserved areas. There's also a Department of Health and Human Services waiver for physicians that only works for primary care, which includes hospitalists but would not include any specialists, and you must be working in a medically underserved area. The Veterans Administration can sponsor people for J1 waivers. They oftentimes don't. There's an Appalachian Regional Council waiver, which does not include KU-Med, and neither does the Delta Regional Authority, but some parts of the United States have additional physician waivers available for people who are working in more remote or medically underserved areas. The J1 physician waiver generally requires the doctor to work for at least 3 years in H-1B status before they can file for permanent residency, or at least the last step of the permanent residency case, the I-485 adjustment of status. But many physicians, we do work with a lot of Conrad waivers to try to get physicians waivers to stay in the United States. A no objection letter does not work for the physician. A hardship waiver, however, can work for a physician or for anyone. So the J1 hardship waiver can be granted instead of any of the above waivers, including physicians, if completing the 2-year home residency would cause an exceptional hardship to a U.S. citizen or permanent resident spouse or child, or if the individual would be subjected to a persecution claim if they returned to their home country. This looks a little bit like an application for asylum in the United States, but the standard tends to be a little lower. So for example, during the Civil War in Syria, initially there were a lot of Syrian physicians receiving medical training in the United States, and many of them were able to seek a J1 hardship waiver or persecution waiver because there was some documentation that if they were to return to their home country, that they could be subject to persecution by the Taliban. Similarly, if someone were here from Afghanistan this year getting training as a U.S. physician, we would expect that they may be able to file for a persecution waiver. We have filed persecution waivers or are aware of persecution waivers that have also been filed for physicians from Venezuela, for example. So there are areas of the country where the government is sensitive that people that have maybe received training in the United States could be under threat if they were to return to their home country. If someone is subject to the 2-year home residency requirement and is not able to get a waiver or not able to get a waiver in time, there is something called an O1 option. An O1 does not require a J1 waiver. It will not allow you to change status from the United States. You have to actually leave the United States after your O1 is approved and apply for a visa stamp and then enter the United States. But the O1 is a non-immigrant status that allows work with the U.S. employer. A beneficiary of an O1 must demonstrate sustained national or international acclaim. So typically we're looking at a researcher, most often with a substantial research record, someone who may have had a number of publications. Those publications have been cited. That researcher has given some talks at some international or national conferences. Sometimes we might work with physicians who may be using a specialized procedure that's not used by anyone else in the United States, and they may have written about that or can document that people are coming from other states to receive this treatment. But individuals can go from J1 to O1 without getting that waiver. An individual can go from a J1 to an F1 without getting that waiver. But if someone wants to get an H-1B, which we're going to talk about in a minute, you do have to have the waiver unless you are a citizen and have a Canadian passport. And then you need to talk to Arena and Kimberly and me about that, because there is a slight exception based on the way the regulations are written, where we can sometimes get people from Canada in on an H-1B for a short period of time while they work on the waiver. Okay, other common non-immigrant work visas. I'm going to talk a lot about the H-1B, but there are, for example, if you have a TN, you may be eligible for a TN if you have a passport from Mexico or Canada. The TN is given under the NAFTA schedule of professionals. It's now called the Canada-US Mexico Free Trade Agreement. It's got a different name, but it's still called a TN visa. And that oftentimes will work for someone who might be a researcher or have another type of faculty position in the United States. It does not work for doctors who are providing direct patient care. An E3 for citizens of Australia. So if you have an Australian passport, you may have some options that are additional options. An H-1B1 for individuals from Chile or Singapore. An O1 again for individuals with extraordinary ability. A J1 for exchange visitors, professors, and researchers. Again, there's an L1 if you've ever worked overseas and you work for Citibank and now you want to work for Citibank here. I don't think that's very relevant to KU, to KU Med, but sometimes we do L1s. And then there are people who are making a substantial investment in the United States, an E2 investor. Generally, you're going to be wanting to look at maybe $200,000 worth of investment, more or less. So I'm gonna go into my discussion about H-1Bs, but I do kind of want to let you know that there's another world here that might be available depending upon your passport or whether you're absolutely amazing. And it's not just your mother who thinks so, that you can actually document that you really do have some extraordinary abilities. So for an H-1B, let's go through the requirements of the H-1B. It requires the foreign national to have a bachelor's or equivalent in a professional field, okay? A professional field is more narrow than one might think. Not all bachelor's degrees qualify for professional fields. Again, I don't see this so much at KU Med because you have all of your allied health professionals there, which would all qualify for professional fields. But for example, at KU in Lawrence, I typically give this type of talk, and there might be someone who is studying, for example, getting just a plain liberal arts degree, or might be getting a degree in business administration without a particularly mathematical or quantifiable major such as finance, accounting, or economics. The government doesn't typically consider those more general degrees to be considered professional level degrees. Some sample specialty areas for professional: biology, chemistry, hard sciences, engineering, architecture, computer science, medicine, and the health fields are typically considered to be professional degrees. Once you have the professional degree, you also need to find a job that requires at least a bachelor's degree in a professional or specialty area or a very closely related field. So for example, an architecture position requiring a degree in architecture, or a civil engineering position requiring a degree in engineering, a research position requiring a degree in biology or chemistry, right? Or an occupational therapist or physical therapist where the position requires at least a bachelor's degree, right? Here is where many allied or some allied health professionals are considered to be professionals, but the government doesn't consider them to be professionals. So, for example, a nurse does not qualify at the bachelor's level for an H-1B because the position only requires an associate's degree. There is possible to be a BSN, and of course, all employers prefer bachelor's of nursing degrees, the BSN degree. But an H-1B would require that no one could be a nurse without a bachelor's degree. And in fact, nurses can get nursing degrees with only an associate's degree, and RN does not require a bachelor's degree. Now, an advanced nursing specialty does require an advanced degree in nursing. So for example, a nurse practitioner or a nurse anesthesiologist. Those do qualify for an H-1B because you cannot get a license to practice that occupation unless and until you have an advanced degree. So it does not work for any generalist positions like a sales job, data entry, simple computer programming positions, and administrative positions. Interestingly, I oftentimes get called by universities. We do a lot of work with universities to try to help get H-1Bs for people who work in something like human resources or in the international office, right? And oftentimes those jobs require that you have a bachelor's degree in a field, right? They want someone who's got a college degree and has a university experience and can write and use analytical skills and think critically. But any degree will work, or almost any degree will work. And those types of positions oftentimes are looking more for someone who has a particular life experience that they bring to the field. So we oftentimes do see that people we cannot sometimes get asked to do H-1Bs for people who are highly qualified, but whose jobs are not considered to be quote unquote professional by the government. And that's just something that's important to keep in mind. Okay. Some other H-1B considerations that are important for both employers and employees to know is that the H-1B is the employer's petition for the foreign worker, okay? The employer has to pay what's called the prevailing wage for the position. And, Irina and Kimberly and Sarah Newlees and I talk about this a lot because the prevailing wage comes from a Department of Labor database, and sometimes they're ridiculously high. Sometimes they do not seem to reflect real world experiences. The employer needs to cover the costs of the H-1B. They need to cover any legal fees or administrative fees paid, as well as the filing fees for the H-1B. If the H-1B worker is terminated before the H-1B end date, the employer actually needs to pay for a ticket home unless the employee quit, right? That's changing a little bit. There has been a new case on that says only if the employee is actually going home. But the safest thing to do is to certainly offer to get the H-1B worker a ticket home. The employee must be qualified at the time of filing. So we frequently work with physicians, and in order to get trained to get licensed in the United States and Kansas, you must have 3 years of U.S. training. So we will see residents who we are trying to get an H-1B for, and their J-1 program might end on June 30th, and they've had 3 years of U.S. training. We can't get the license until July 1st from the state of Kansas, and then we can only then can we file the H-1B. So we do have quite a bit of timing considerations with this issue, where you must be licensed at the time of filing, not at the time that the H-1B is not at the H-1B start date request. If you will work for an employer that is not a college or a university or a closely affiliated not-for-profit, there are some critical timing issues to keep in mind. This does not apply to individuals who are working for KU Med. This does not apply to individuals who are working for UKP if you have a joint appointment with KU Med. But the critical timing issues to keep in mind are that the H-1B, the USCIS only issues 85,000 new H-1Bs in any year outside of a university setting or a academic medical center type setting. 65,000 annual cap plus 20,000 for employers who are seeking workers with a U.S. master's degree or higher. Again, not all employers are subject to the H-1B cap, but if I have any physical therapists on the line, and you're planning to go out and work for, Johnson County Physical Therapy, for-profit company, you are going to have to go through this H-1B cap. In order to go through the H-1B cap, you have to go through a lottery. The lottery or entry period is announced early every year, and the lottery is held in March. So if you are planning to work in the private sector, even for a nonprofit that's not affiliated with the university, you need to request H-1B sponsorship from your employer no later than January. This is really important because sometimes it's necessary to enter the lottery more than once. There's about a 30%, 33% success rate on lottery entries. And the reason for that is the government tends to receive 3 times more H-1B requests than there are new H-1Bs available. Your other option is stick with KU Med, it's a great employer, or continue to work in academia for another institution, and you will not have to worry about going through this quota. If you are, for example, a biopharmaceutical researcher, and you are currently working in H-1B status as a researcher for KU, and then you suddenly get a job offer from Merck, and they want you to come and be a researcher for them, you will have to go through that H-1B cap before you can change from a cap exempt university employer to a cap subject private employer. So that's also important to know. Another important thing to know about the H-1B is that the H-1B has a maximum of 6 years in which you can be in H-1B time. So the longest you can get an H-1B request by an employer is 3 years at a time, but an employee will max out if they have used 6 years of H-1B time and do not have a permanent residency case filed early enough in their 6-year H-1B tenure. So you're going to want to make sure that if you are in H-1B status and you are entering your 4th year of H-1B time, if you have not talked to your employer about that, you need to start looking into it, because it can take a year or 2 to get far enough along in the process to continue to extend your H-1B. If you don't make the H-1B limit, if you don't get a permanent residency case filed early enough, you can leave the United States for a year and then be eligible for another 6 years of H-1B time. I do need to say that at any given time, we are working for someone who has waited too long, and we are racing to try to get them continuous work authorization and continuous eligibility to remain in the United States because they did not start a permanent residency case early enough. So if you are in year 4, at the beginning of year 4, you should not be waiting. You should start to think about and look into your options for permanent residency. Okay. Another thing about the H-1B is that although your H-1B is not valid the first time until it's approved, so if you have STEM OPT and you have filed for a change of status to H-1B, until that's approved, you are not in H-1B status and you cannot work in H-1B status. And if your F1 OPT expires before the H-1B is approved, you need to stop working and can be terminated from employment. Once you get your first H-1B, if you change employers, then the new employer only has to file a new H-1B for you to move from employer A to employer B. It does not have to be approved if you are staying within your cap exempt employer sponsorship. So if you moved from the University of Florida to KU Med, you're allowed to start working at KU Med as soon as KU Med files the H-1B. It does not have to be approved. So that's kind of an overview of the non-immigrant options. Most people get the H-1B. It's not applicable for everybody. Whenever we're talking about what's the best way to move forward, we're oftentimes looking at these options and which one would be the best and how we can get someone work authorization the fastest without having to leave the US or without having to stop working. And we have to oftentimes look at a number of different factors in making that call, including the individual's nationality, where you might have to leave to get a visa stamp if you do need to leave the United States, etc. So that's an overview of the H-1B. I'm going to pop over and talk about permanent residency, and then I'm going to open this up for questions, okay? And I'm going to get a drink of water. Okay, so I'm going to talk about permanent residency through employment, all right? I always want to preempt this by saying that there are better, faster, cheaper ways to get permanent residency in the United States. The best, fastest, cheapest way to get permanent residency in the United States is to marry a U.S. citizen or a U.S. permanent resident, okay? And if you marry for love and not for a green card, you would probably want to preempt all of this by notifying who's ever working with you on permanent residency or whoever is handling an H-1B for you that you are eligible to file through marriage, because that actually is the best type of case where you can get permanent residency the quickest. If you're really far along in an employment-based case, it might not be worth it to make the switch. But generally, if you do find that you've fallen in love with a U.S. citizen or another permanent resident in the United States, that's a very, very good way to get permanent residency yourself. It's also a great way to get thrown in jail and a great way to never be able to come back to the United States if it is a fraudulent marriage. You should know that it holds both criminal penalties and is an absolute bar to reentry to the United States if there is a finding of fraud in a case like that. So it's really important that it be a legitimate marriage. We also see people enter the diversity visa lottery. The government gives 50,000 green cards for free to people who are applying from countries of low immigration to the United States. That window just closed. It was open from October 8th until November 8th. We really encourage people to apply for it. It's not like Powerball. We see usually that every year we hear about one or two people who have won the diversity visa lottery, and timing is very essential on that. And so it is important to talk to a specialist about that after you know that you have been selected. You can very easily enter the lottery on your own. And in fact, the Department of State and most immigration attorneys say you do not need to pay anyone. You can do it on your own. And only once you're selected and notified would you want to maybe seek the opinion of a specialist. Again, people also get permanent residency through asylum, through refugee status. If you're a victim of a violent crime, you might end up getting a U visa and being able to get permanent residency that way. But I'm going to talk about what most of you are likely to experience, which is permanent residency through employment. And with that, we're going to talk about EB cases. So what does EB mean? All right. EB means employment-based. All right. And there are different categories of employment-based cases. So there is a EB3, which is a third preference employment-based case. There's an EB2, which is a second preference, and an EB1, which is a first preference case. So there are different categories of permanent residency, and they are all limited by country of birth and within the category. So there are, a certain number of green cards that are allotted for third preference cases. There are certain numbers that are allotted for second preference and a certain numbers that are allotted for first preference. There's also a fourth preference and a fifth preference for investors and for other people in the United States, but we're not going to talk about those kinds of cases. But I do want to go through so that you understand that there are categories of preferences. And that's important because the government has a quota of 140,000 immigrant visas or green cards that are available each year. This is a very small quota. The quota is divided by preference category and country of birth. So, any of you that have taken economics understand that when supply exceeds demand, right, by country of birth or by preference category, waiting lists may develop that can significantly delay the permanent residency process. All right, this is called immigrant visa availability. It's also called visa retrogression, and it's also called the waiting list, right? The green card waiting list. And so I'm going to kind of go through where we are with this right now. First preference, and we're going to talk a little bit about what you have to do to get into these various categories in a minute. But first preference is for individuals with extraordinary ability, an outstanding researcher, or this multi-executive manager, multinational, if you're working for a multinational company like Citibank or, some company that does business in many different countries. Second preference is a national interest waiver, which we'll talk about in a minute, or a labor certification, which we'll also discuss, for jobs that require an advanced degree or at least a bachelor's and 5 years of experience. Right now, there is a backlog or a waiting list for China and for India. For China, the visa retrogression, the backlog, goes to June 8th of 2019, and the India backlog is April 1st of 2014. The third preference is all other labor certifications, and again, we'll talk about those in a moment. China is backlogged to June 15th of 2018, and India is backlogged to April 1st of 2012. Again, so if you are from China or from India, one of the first things that we do is we try to see, can we get you up into this higher preference category, the first preference? Would you qualify for a case in that higher preference where there's no waiting list? If you are from France, we're not going to try to get you into a higher category, right? Because there's no waiting list. It's just as long as it takes the case to be processed. We might look and see, might you qualify for a national interest waiver? Could that go faster for you than a labor certification? But there's no advantage necessarily in trying to get you into a higher preference category. Similarly, unless you're from China or India, whether you fall into this third preference or this second preference is immaterial. So let's talk about first preference. These is the best if you qualify. Extraordinary ability is for an alien, and I'm sorry, that's in the law. I didn't make up that term. Must have a demonstrated ability through sustained national or international acclaim, and this extraordinary ability must be recognized in the aliens field through extensive documentation. The thing about an EB-1A is that it is and can be a self-petition, meaning you do not necessarily need a job offer to qualify for an extraordinary ability case. The problem is that the word sustained typically means significant research past the PhD, several years, meaning sustained over many years. You can show documentation. So what does it take? What does it take to start to talk about this kind of a case? In most situations, I generally recommend, this is a rule of thumb, but I generally recommend if you're at about 20 publications and maybe 400 or more citations and some other strong evidence, like you've done a lot of peer reviews or you're on the editorial board of an international journal, then we can talk about that. If you're on the editorial board of a very strong first quartile journal and you have don't have quite as many citations, then we can still talk about that. So extraordinary ability, again, really is for individuals who are fairly famous or who have won, for example, the Nobel Prize. If you've won the Nobel Prize, you can take an I-140 form, you can attach Exhibit A, Nobel Prize, and you will get a green card, I promise. So that's also an option. But otherwise, you're going to have to show that you have extensive documentation in several other categories, including publications, judge of the work of others, you've been written about, you have a lot of citations to your research, you may have played a key role for an organization, etc. There's another kind of case. This is an employer-sponsored case, meaning that your employer has to agree to sponsor you. Your employer doesn't have to pay for this, but they do have to agree to sign forms. And this requires that you show that you are an outstanding professor or researcher, and you are recognized internationally as outstanding in the academic field. Okay, so what does it take to win on this? Well, we generally start looking at this. Do you have 10 or more publications, 100 or more citations, and some other strong evidence? You might not prevail without more than 10 publications and 100 citations. We typically have a conversation to look at sort of the metrics that the government looks at, but the government's going to look at, for example, have you won some prizes or awards? Did you win a best paper award? Are you a member of Sigma Psi, or are you a member of the National Academy of Sciences, or some sort of professional group that requires nomination to be a member? Has someone written about you? Is there a review? Is there a review article that discusses your work at length, or have you been written up in Yahoo News or in Time Magazine? Have you judged the work of others? Have you done peer reviews for academic journals? Have you made some original scientific or scholarly research contributions, for example? And so this is what the initial evidence that you have to submit. And then there's a second stage of the review. You will not win on an EB1 case unless the quality of the evidence submitted demonstrates that you have extraordinary ability or that you are internationally recognized as outstanding in your field. If you only have 2 publications, you've met that criteria, but the examiner will not be convinced that with your 2 publications you are internationally recognized unless those 2 publications were published in Nature and have 700 citations or something along those lines. So it's very important for you to understand that the weight of the evidence needs to convince the examiner. The other thing that you need to know about the outstanding professor or researcher is that it does require a permanent job offer. This means that it does not have to be tenure track necessarily, but if it's a research position, you have to have a history of funding and anticipated continued funding, and it does not work for postdocs because postdocs by their nature are not permanent. Another kind of case that we look at a lot for people, because it is a self-petition, this works very well for postdocs who have a publication record, is whether or not your work is in an area of substantial merit and national importance, whether your track record shows that you're well positioned to advance the endeavor, whether it's beneficial to waive the labor certification. What would get you into a self-petition EB2 case? Generally, I'd like to see maybe 5 or more publications, 30 or more citations. There's a January 2022 Biden memo that came out. We're not sure how this is going to unfold, but it does favor advanced degrees in the STEM fields and may make it easier for STEM professionals to obtain national interest waivers even with a lower standing. So this is important to know. People who are postdocs, this can be a really good way to sort of get a case on file, to get a work card if you're not from China or India, and you know that when you finish KU Med, you would like to go and be able to get hired on as a professor or a researcher in another institution without having to go through the H-1B sponsorship necessarily. And this is one way to do that, which is helpful. There's also a national interest waiver for physicians. The national interest waiver for physicians requires the physician to have a contract to work in a medically underserved area for 5 years. And interestingly, if you are subject to that 2-year home residency requirement and you are completing a Conrad waiver, you are allowed to file for adjustment of status earlier than your 3-year completion, but you will not get your green card approved until after 5 years. We typically talk about national interest waivers for physicians if there is a spouse who is needing work authorization sooner rather than later, or if an individual is from India or China and would like to establish what's called a priority date. The date that we were looking at earlier, 2012 for India, 2018 or 2019 for China, that's the date that your first step of your permanent residency case was filed. And so this can allow, that determines your place in line, and it does not preclude you from filing another permanent residency case in the future. So we oftentimes will see physicians from India or China who would like to take advantage of the national interest waiver filing because it would get them a priority date, and if in the future another avenue opens up, they can do that. For those who are not researchers or who are new researchers, for those who are in the allied health professions, or if you are a staff professional like an IT person or a clinical research coordinator, for example, the kind of case we would typically explore for you is called labor certification. Labor certification is generally appropriate for positions that are hard to fill or that produce few U.S. worker applicants because of location or schedule. So what is a hard to fill job? Well, a hard to fill job basically is one where the skills and the experience and the education are unusual in order to perform the duties of the position, or where nobody wants the job. So for example, we do a lot of medical technologist cases for small hospitals in western Kansas for medical technologists who are on the night shift, because US workers who have degrees in medical technology typically do not want to work in western Kansas and do not want to work on the night shift. And because those jobs are undesirable, it's easy to get a labor certification case. If I were trying to get an entry-level medical technologist a labor certification in Kansas City on the day shift, I wouldn't file that case because those jobs are not hard to fill. So it can be location or schedule, or it may be that you're conducting research in a particular area that's very unusual and you have some skills that are needed by your advisor in order to do the labor certification case. And so that means that there aren't a lot of people who have that particular cluster of skills that's necessary to perform the duties of the position. Labor certification is unusual because it requires the employer to go out and actually run ads for your job, even after you're sitting there. So you will be sitting there in your position, and nearly always the employer actually has to go out and put ads in the Kansas City Star, put it on the KU website, post it with the state workforce agency, and also use a couple of other methods of recruitment, and then look at every single resume that comes in to see if there is a minimally qualified US worker who is available for the job. When we're trying to figure out the labor certification, what's minimally qualified, it doesn't necessarily mean that the worker has all of the same background as the sponsored foreign national. It means that the worker has the experience and skills and education that are both reasonable and essential to perform the duties of the position. It does not allow the employer to screen based on who is the best qualified or to look at whether an individual possesses a preferred skills, but whether there's a minimally qualified interested US worker who's available for the job. We spend a lot of time on these cases articulating what those requirements are, making sure that we remove anything that's simply preferred, but that we haven't missed anything that's absolutely essential to do the job. And those can take quite a while to get through. If an individual is a faculty member with teaching duties, we can sometimes not do new recruitment and basically go back and make sure that as long as the position was filed nationally, recruited nationally in a journal, then as long as we can file that case within 18 months of the selection date, we can skip that recruitment process that the employer would otherwise go through. There are also special labor certification cases for physical therapists and for nurses. Those are called Schedule A. It does not require that someone go out and do a labor market test, which can take a year or a year and a half to get through that labor certification process. Something that is important to note is those cases are filed directly with the USCIS. And while we can't get H-1Bs for most nurses, we oftentimes can file the I-140 and the 485, and the nurse can get work authorization if the case is started early enough. Nurses and physical therapists and allied health professionals need to know that even if they were educated in the United States, they need to go through a special certification board called CGNFS to show that their education is equivalent to a U.S. degree, even if they have a U.S. degree, and they have to show that they speak English, even if they come from an English-speaking country. So it's very important for the allied health professionals to understand the broad scope of CGFNS certification and that you need to start on that before anything can be filed with the USCIS. I'm talking really fast here, Rena. I've gone a little bit over, haven't I?
No, we still have time. I think we
Still have time. Okay. All right. Okay. After the labor certification is filed, and which is or the I-140 is filed, there is a last step of a case called the I-485 adjustment of status, and that's where the USCIS is going to look at the international workers' individual eligibility for permanent residency in the United States. And there are some individual eligibility questions that we'll talk about in just a minute. But at the I-485 stage as well, the employee's family members, the spouse and children, can apply for permanent residency along with the employee. So that's when they get included, is at the very last step. When we file the I-140 petition, the USCIS looks to make sure this is a real job and that you're not being sponsored by your cousin's brother, and that the employer actually is an established company that has the ability to pay your salary. At the 485, the government's going to look to make sure that you have obeyed the rules in the United States. Have you abided by the terms and conditions of your non-immigrant status? Have you committed serious crimes? Some of the things that the government is going to look at are just that. They're going to see, have you had any arrests or convictions that make it impossible to become a permanent resident? Be very careful, not only for you all. I'm sure you're not going to be breaking the law, but you do have to be careful about your children, particularly with drug offenses. I am telling people that the use of marijuana is considered illegal under federal laws. And even though in many states, including it looks like now Missouri, recreational marijuana or even physician prescribed marijuana is legal under state law, it's not legal under federal law. So it's very important that you and your family members know that use of marijuana and an arrest for use of marijuana can be very significant. The only thing that's excused under federal law is simple possession of 30 grams or less of marijuana without intent to distribute. So you want to be very careful about any kind of drug abuse or arrest. Be very, very careful about that. A status violation can make it impossible to become a permanent resident. We see all the time that principal applicants forget to file for their family members. And so they'll have H-1B status, but they won't file the H-4 for their family or won't extend the H-4 for their family. Or we'll see that a spouse or child might work without authorization and accrue something called unlawful presence. If someone goes out and completes an I-9 and says you're a U.S. citizen, that can make it impossible to become a permanent resident. That is a false claim of U.S. citizenship. The local offices go back and forth on that. Sometimes completing that I-9 and saying you're a U.S. citizen is considered a false claim. It kind of depends on who's looking at it. But you want to be very, very careful to make sure that you follow the immigration rules. Other common grounds of exclusion include prostitution, communism, support of terrorist organizations, and some foreign organizations, some overseas charitable organizations might be deemed terrorist organizations or supportive terrorists organizations in the United States. You might want to check the State Department's website about that before giving money to overseas entities. Polygamy is a ground of exclusion in the United States, and you will also not be approved for a for permanent residency if you have not complied with the 2-year home residency requirement and you were subject to that. So all in all, that is my, I've gone over a little bit. That's my big overview of non-immigrant work visas and permanent residency through employment. It's a high level, and I've tried to kind of give a framework. And at this point, I'm happy to answer any questions that you ask that I'm able to answer. So.
Judy,
Yes.
thank you so much. You always give such a great presentation, and we actually scheduled you for an hour and a half, so you're good.
Okay,
you did
good,
a great
good.
job. Because we know there's a lot of questions. I just want to take an opportunity to remind everyone that we have a policy that for the cases of employment-based permanent residency and the O1 visa, that we work exclusively with you as the university approved attorney. And there's a process outlined on our website that people can find. It can start with Arena and OIP, and she'll facilitate that process. But I know that sometimes people are tempted to look at the internet and find a lawyer, or they think they need to, right? They think they need to find their own representation, and that's not the case. They should work directly with us because it's employment-based, means the university has to sign off on it. And if the university has to sign off on it, you have to review those documents. So.
Right, and the exception for that would be a self-petition national interest waiver or a self-petition EB1 case, EB1 extraordinary ability case. I do want to caution people, particularly about the extraordinary ability EB1, that we do see a lot of people who have filed those cases, they've gotten denials, and then they end up going back through the queue with KU Med trying to get the EB1B sponsorship through an outstanding researcher, and you can end up, it can be very costly to do that. So again, I'm happy to talk to people. We do have complimentary consults for people that are at least in the ballpark, where we'll go through and make some recommendations about what might be the fastest, best way for you to get permanent residency in the United States. Okay.
Are there any questions out there for Judy? I didn't see any in the chats so far. So.
Oh, wow. Gosh, last year at this time, there were so many. Let me see. Okay, we got some, I'm seeing some. Oh, okay, you answered the question of polygamy. If someone was a past polygamist, that's okay, as long as you're not a current polygamist. So, there are some things that are waived. I did have an interesting case with someone a while ago, and at one point he'd had 3 wives at the same time. So, but it wasn't a problem as long as we could show that he had divorced 2 of them. So there wasn't an issue.
If it's okay, I can ask a question. I know we
Sure.
always get like rumors about like upcoming changes or updates, whether regulatory or policy wise. Do you, through your channel, see of any potential changes that could affect our community?
You know, we've had some interesting things that have happened in the last few years. This is usually where I get thrown off base because you know, we had so many things that were on the regulatory agenda during the Trump administration, and then with COVID, there was so much information about could you travel, could you not travel, and that was very confusing. Right now, I would say that things are fairly quiet. Most of what we have seen is good. The employment categories benefited significantly from COVID, actually, because a lot of immigrant visas that could not be used overseas from families coming in poured into the immigrant categories the last couple of years. And in fact, this year, I think there's an extra 55, something like that, thousand immigrant visas that are going to be made in addition to the 140,000 through employment. So the quota will be a little bit higher. We are seeing, we're very interested in the Biden memorandum that is favoring STEM degrees. There are a number of rumors that the lame duck session at the end of the year might be putting through some great grand new immigration bill with the appropriations. They tend to put those things through in the budget because they don't need a majority of 60, a supermajority, in order to get through. From my perspective, I typically take the position that until I see that it's passed, I don't get too excited about it. We've been concerned about DACA. You know, we've been concerned about TPS. Those things seem to be moving forward. One of the things that we are very frustrated about, there's some litigation that might be might go into play against the Department of Labor because they're not giving prevailing wage determinations for labor certifications. Labor certifications are taking way too long. But that's basically it. Have you heard of any arena that you're particularly interested in?
No, but that's a common question we kind of get. So
Yeah, and I tell people, you know, it's kind of good to keep an eye out, but you know, don't start hiring attorneys to help you with things, because after 25 years, we have seen so many various proposals that have been put into place, and very, very few of them have ever come to fruition. And then it seems that whenever something does come to fruition, it's a surprise. You know, we're not expecting it. So again, you know, you can spend a lot of time speculating, but I'm not anticipating any change based on what I'm hearing right now.
I think we did get a couple of questions actually in the chat.
Okay.
I'll go the first one. One of them I had already responded to is the polygamy question. But one of the questions asked, do EB categories apply to physicians too? Are they considered EB1?
So a physician is a professional, right? And anyone can file in any category for which they qualify, right? So a clinical physician who has no research background is not likely to qualify for EB1, not for extraordinary ability or for an outstanding researcher. So some physicians who agree to work in a medically underserved area for 5 years, we might file an EB2 national interest waiver, a physician national interest waiver. Sometimes a physician at KU might have a research background, and we might file for a research-based national interest waiver. But in order to get into those EB1, extraordinary ability or outstanding researcher categories, the question is, do you have extraordinary ability as a physician, right? Through sustained national or international acclaim, or are you as a physician also an outstanding researcher who is internationally recognized as outstanding? And that's the question of whether or not you can get into that EB1 category. Hope that answered the question.
Thank you.
How did how did communism end up there? Let's see. Yeah, it is a relic from 1954, but it actually reared its ugly head during the Trump administration. So it's becoming a much bigger issue now. There are waivers if you haven't been an active member of the Communist Party for 5 years. It's generally excluded, but we are seeing that it's becoming a bigger issue right now for people from China in particular. Yeah. Okay, let's see.
What about DACA? What's happening on the DACA front? What are some of the developments?
It depends on the day. So with DACA, if anything goes through the lame duck, it might be, they're saying they might codify DACA. What's happening with DACA is that there is a battle in mostly the southern states where they are saying that DACA is illegal, and the U.S. that what typically gets impacted is whether new DACA applicants can file. So there are age requirements. The individual must have been between the age of 15 and 30 and had to have come here at a certain year. So someone who may have come during the required time period and is just now turning 15 or 16 can't be a new DACA applicant. And so the new DACAs are not able to apply. For right now, I just filed a DACA renewal. There's a case that came out where they're saying that they can't, but for right now, as I understand it, the USCI is still accepting DACA extensions at this point in time. Okay, let's see.
I think another question related to that, if there's any news out there about an actual status transition for DACA or the status for DACA.
Again, DACA isn't a status. It's not a non-immigrant status. It does give you work authorization, but it doesn't allow you to become a permanent resident or get sponsored through employment or anything like that. If you did marry a U.S. citizen and you had an entry with inspection through the United States, you might be able to get permanent residency that way. We've helped a lot of DACA kids that way. But right now, there's a lot of discussion that they're going to codify this, and it might be something that happens in the lame duck session, but that's the most I know about it. I'm not a DACA expert. We do a handful of DACA cases in my office. And most of the DACA cases that we started with, we at one point we had a lot of them, but most of the ones we have now have actually gone on and become permanent residents or U.S. citizens through other means.
Right, so there's a couple of questions that came in. One of them is, do you suggest that we apply as soon as we have more than 5 publications and 30 citations for the EB2, or try harder and wait until we meet criteria for EB1 if you're especially from China and India or India?
Well, I think in that case, you have to look at a few different things. How much time do you have, right? And so oftentimes for someone from China, I will say, go ahead and file the EB2 as early as you're eligible, because it might take you another few years before you get to the EB1. That's a harder case to win. And by the time you get to have an approvable EB1 case, your priority date might be current in the EB2, right? So the wait list for China is not that long. I mean, it's 3 years, right? But it generally takes 2 years to get through the process anyway. So the first step, can be quite a long ways, and it ends up being reasonable. A lot of times for EB1, if you're from India, if you're close, and you still have a lot of H1B time left, then I would recommend waiting. If you are not close, and you're worried about running out of H1B time, remember, you need to get through the I-140 petition before you can continue to extend your H1B in 3-year increments. And you need to get a permanent residency case filed by the end of your 5th year of H1B time. So I will say that, frustratingly, I have had some Indian clients, including physicians, who have not filed early enough, and where we have been scrambling at the last minute to try to get them some sort of a fallback work authorization. The USCIS used to expedite national interest waiver cases that were filed during the 6th year when someone was going to run out of H1B time. They are not expediting those now, and they can't be premium processed. So I would say if you are in your 4th year, I would recommend that, and you're at KU Med, I would recommend that we have a discussion about that, because you don't want to run out of your H1B time, and it might be worth it to just go ahead and get that EB2 on file to know that you can wait take the time that it's needed to strengthen your application to file for EB1 if you need to do that. Okay.
I did have one question that came in related to J1 hardship waiver.
Okay.
And, it was basically asked, can a J1 hardship waiver be filed based on an unusual health condition of a spouse or child requiring treatment in the U.S. who is not a citizen or a permanent resident?
I don't do a lot of hardship waivers, but you have to show, you need to show hardship to a U.S. citizen or permanent resident. Not just, I will get back with you on that, but it typically needs to be, to get that J1 waived, you need to show the hardship to the U.S. permanent resident qualifying relative.
Thank you. I think we're caught up on the questions in the chat.
Okay.
Were there any other last minute questions from the group today? Well, I guess that's a wrap. Thank you so much, Judy.
Okay, great. I was trying to get through it to allow 30 minutes for questions, because last year we had so many questions, and they were all really hard questions too. So anyway, I'm glad. I hope if anybody has questions, after the fact, you can shoot them to Arena. Feel free to shoot me an email. We always enjoy, working with KU Med. We've got a great partnership, I think, with Arena and Kimberly and Stacy, always very helpful, and have been working for a really long time with a lot of the administrators from the various units. And so we're quite happy to work for you all, and want to be as helpful as we can to finding the best solutions for all of the employees at KU Med. So thank you for having me. I appreciate it. And I'm sorry this presentation is so dry. I can't, there aren't a lot of jokes we can tell about immigration, especially when we're trying to get through all the information in a short period of time. But I appreciate your having me, and I hope you all have a great day. Okay?
Thank you, Judy. We appreciate
Thank you, Judy.
Thanks. Happy International Week.
you.
Thank you.
Okay, thanks. Bye-bye.